So, welcome everyone. My name is Dana Smith, and I am an associate professor of Holocaust and Genocide Studies here at Keene State College, as well as the assistant director of research for the Cohen Institute. Today's program is part of the Institute's series of critical response events. These events are meant to promote understanding and conversation about emerging and ongoing crises and critical topics throughout the world. Today, we will be focusing our attention on the international prosecution of genocide. The goal for this series is to promote a wide range of viewpoints and expertise. The views and opinions expressed by guest speakers are those of the individual and do not necessarily reflect or represent the views or positions of Keene State College, the Cohen Institute, facilitators, and/or other participants. Our format for today's lunchtime discussion will be as follows. We will have about 30 minutes of presentation and discussion by our guests, followed by about 10 minutes available for questions before we wrap up. Audience members may submit questions to the moderator using the Q&A function in Zoom. We ask that individuals wishing to suggest questions please frame their inquiries in a respectful and open-minded manner. We welcome questions that highlight intellectual rigor, curiosity, and common courtesy. We may need to reword questions at times for clarity, and we may not be able to answer every question posed in the chat. I would also like to remind everyone that unauthorized video, audio, or other recordings of today's events are prohibited. The facilitator for today's event is Dr. Phil Barker, Professor of Political Science at Keene State College and Cohen Institute Specialist for the 2025-2026 academic year. I will now turn the floor over to Dr. Barker, who will introduce today's presenter and facilitate the conversation.
Thanks, Dana. Good afternoon, everyone. Welcome. As Dana said, I'm Phil Barker. I'm Professor of Political Science and Director of the Morris August Honors Program and a Cohen Institute Specialist. And I have the honor of moderating today's discussion hosted by the Cohen Institute. So we're glad you're here for what promises to be, I think, a really interesting discussion and a bit of a follow-up to a conversation that we had back in the fall. And today we're going to focus on the international prosecution of genocide. So we talked in the past about the International Criminal Court and what it does. And what we wanted to do today is to dig in a little bit and talk a little bit more about the International Criminal Court and the International Court of Justice and the roles that they play in actually prosecuting cases of genocide. And in doing so, look at a few of the cases that are actually in process now and that have, as well as some cases that have played out in the past. To help us explore these questions, we are thrilled to be joined again by Mariana Salazar, a leading international lawyer and scholar with more than 20 years of experience in international criminal law, human rights, and atrocity prevention. She served in high-level roles with the UN and the Organization of American States, and she currently teaches in Madrid and Mexico City while contributing to the International Review of the Red Cross and the Mexican Council on Foreign Relations. She brings extraordinary expertise and firsthand insight into how international law actually operates in the real world. And as we mentioned before, after her presentation, we'll have some time for questions and answers. So please feel free to add those questions in the chat. So welcome, Mariana. Thank you for joining us again. Today, you and I had talked about various ways to move forward with this. And I think maybe we can begin, as we start talking about the international prosecution of genocide, maybe we can begin with you just talking a little bit about the legal definition of genocide, and then we can sort of use that to talk about the court's role. So I'll hand it over to you and let you sort of proceed as you wish.
Thank you very much, Phil, and thank you to the Cohen Institute for the kind invitation. It's an honor to be with you again. Yes, so the definition of genocide goes back to the 1948 Genocide Convention, the Convention on the Prevention and Punishment of Genocide, of the crime of genocide. And it is defined as any of 5 acts that are committed with an intent to destroy in whole or in part a national, ethnic, racial, or religious group as such. These 5 acts can include killing members of the group, causing serious bodily or mental harm to them, deliberately inflicting on them conditions of life calculated to bring about their physical destruction, imposing measures to prevent births within the group, and forcibly transferring children from one group to another. A lot has been said in jurisprudence throughout the last decades to kind of understand and delucidate this meaning and how it should be applied in practical cases. Definitely, what stands out the most from the definition of genocide is the fact that it has a what we call a dolus specialis, a special intent that goes further from the intent of each particular conduct. That means that there is the special intent to destroy a group as such, that the killings or that the mental harm or that the conditions inflicted on the members are caused because of their membership to this group. So genocide is, as Lemkin originally foresaw, is a crime that is created to protect groups as such.
Do you want can you talk a little bit about you've got up here there's a couple of different ways of essentially holding individuals, groups accountable. Do you want to talk a little bit about how the different courts come into that? You and I had talked a little bit about the International Court of Justice in particular. Do you want to discuss that a little bit?
Absolutely. So the 1948 convention is a convention that is adopted by 154 states parties to the state, and it is a convention that, under Article 9, foresees the possibility for any dispute among those states concerning the interpretation or the application of that convention to be taken to the International Court of Justice. The International Court of Justice, as the judicial organ of the UN, decides on contentious cases among states, so it sees state responsibility. But genocide is also, of course, a crime that brings along individual criminal responsibility. And that is why the same definition that is contained in the 1948 Convention was retaken and was included in what is today the Rome Statute of the International Criminal Court, which was adopted in 1998 and entered into force in 2002. So genocide is one of the crimes that the International Criminal Court can prosecute, and it has precedent in the ICTY and the ICTR, which are the international ad hoc tribunals that were created in the decade of the 90s after the Balkans War and after the genocide in Rwanda. So there have been international cases in the ICTY and the ICTR where individuals have been prosecuted for the crime of genocide already. In the International Criminal Court, there has been one arrest warrant issued for genocide, and there have not yet been cases of actual judgments for genocide yet.
So just for to kind of reiterate the difference, so the ICJ is dealing with cases between countries and is dealing then therefore with the country's responsibility, whereas the ICC is dealing with individual responsibility. So the difference would be bringing a case against Russia as a state would go to the ICJ, and bringing a case against Vladimir Putin would go before the ICC.
Exactly.
Yeah. So so you talked a little bit there. There's precedent with both of these. I mean, the ICJ has done a bit more of this prosecution in terms of genocide specifically. Do you want to walk through, or can you walk us through some of the previous cases, or kind of what this looks like when the ICJ actually handles a case regarding genocide?
Sure. And in fact, we are in an unprecedented time where the ICJ is seeing four ongoing cases under the Genocide Convention. And I will show you the list of these four cases. There had been two previous cases presented in the 90s regarding, again, the Balkans War in the ICJ. So let me just share my slide. So as you can see, in the past, we had already had two cases, one of which was initiated in 1993 by Bosnia-Herzegovina against Serbia-Montenegro, and one of them which was initiated in 1999 by Croatia against Serbia. Both cases were invoked under the Genocide Convention, Article 9 of the Genocide Convention, and the judgments for each of these cases were issued in 2007 and 2015, respectively. Then we see now that the court has an unprecedented number of cases regarding the Genocide Convention in four different situations. We have the first of them after the former Yugoslavia cases. The first of them was the Gambia, which presented a case against Myanmar for the alleging genocide against the Rohingya minority. This was presented in November 2019. After the Russian invasion into Ukraine, the Ukraine also filed a claim, a memorial at the International Court of Justice in February 2022. In December 2023, after the 7 October strikes in Gaza, South Africa filed a memorial, also an application instituting proceedings against Israel under this convention. And in parallel with that last one, also Nicaragua decided to file and institute proceedings against Germany a few months later in March against for the aiding and abetting by Germany through its support in financial and equipment measures to Israel for the crimes committed in Gaza.
So the legal questions are always fascinating because you get into, I mean, I think it's what makes these cases so interesting is that uh, we can talk about, genocide as a concept, but talking about the actual enforcement of it as law, you start to run into more barriers. The first thing I think of when I look at these current cases is about questions of standing. So the International Court of Justice, here's cases between countries. Countries have to agree to let the ICJ, they have to agree to some extent to jurisdiction. So can you talk a little bit about I mean, like, what is it that allows South Africa to bring a case against Israel or Nicaragua? They don't seem to be sort of direct participants as opposed to the previous cases where you have, Bosnia bringing a case specifically against Serbia.
Absolutely. So that's the main trend that we're seeing now is precisely this sort of litigation in the public interest. Whereas in the past cases, it was actually an injured state, Croatia, Bosnia-Herzegovina, who were claiming because they were a directly affected state. Here we are seeing that the Gambia against Myanmar, South Africa against Israel, and Nicaragua against Germany, and those three of the four ongoing cases at the ICJ involve countries that are not directly affected or directly involved in the situation. What has been happening is that there has been a recourse to the erga omnes partes concept, this concept which has been reaffirmed by the International Court of Justice, stating that there are some treaties that have such important values in them that are of high ideals, such as the Genocide Convention, and this has been expressly stated by the court. Where all the states parties to the Genocide Convention, because of their shared values and because of their common interest in making sure that genocide is prevented and punished, they can all actually invoke the responsibility of another state party for violation of the convention. So this is actually an exercise of international cooperation, of international moral duty also to cooperate in the prevention of these crimes. And it is an interesting trend that we are not only seeing in the ICJ. In the ICJ, it occurs under this Genocide Convention chapeau. We are also seeing it in the ICC, in the International Criminal Court, where we also see a number of states participating in the referrals of situations to the ICC or in the interventions of situations to the ICC, also regarding ongoing cases of genocides. So the fact that South Africa, Gambia, and Nicaragua could present proceedings against Myanmar, Russia, Israel, and Germany is because they are all states parties to the Genocide Convention.
So I don't know if you know the answer to this. The other one I think of is the Ukraine versus Russia case, because this seems like a case where Russia wouldn't be inclined to accept the court's jurisdiction. Do you know the background of why Russia has agreed to let this case move forward?
Well, there are four ways of referring situations to the International Court of Justice, and often there are states that are very difficult to find a way to be presented before the court, precisely because They do not accept in a permanent manner the jurisdiction of the court, which is the case of Russia. Russia does not have a permanent declaration under Article 36 of the ICJ statute that accepts the competence of the ICJ. But there's another way in which you can actually take a country as file proceedings against a country in the ICJ. And that is if that country is a party to a convention that has a clause that says that any dispute arising under that convention will be settled by the ICJ. In the case of Russia, Russia is a party to the Genocide Convention, and you can only put forward reservations to conventions at the time of becoming a party to it, at the time of signing or ratifying it. So in the case of Russia, Russia did not put forward any reservation to Article 9 of the Genocide Convention, which is the article that gives the ICJ jurisdiction over disputes regarding the Genocide Convention. Therefore, Russia is a party and is bound to any case filed against it under the ICJ, under the Genocide Convention. And Russia is participating in these proceedings. It has recently presented counterclaims against Ukraine, and we are in the process of waiting for Ukraine's reply, which is due in December this year, to those counterclaims.
That's really fascinating. So I think that oftentimes, I remember when the South Africa case was submitted, you hear about these cases in the news, and I think people are, I don't know, they expect a rapid resolution in some way, and that's not necessarily how this court works. You can see from the past cases, some of, the Bosnia case was, it took, they are taking, 15 to 20 years sometimes to play out to their full extent. Can you talk a little bit about the timeline of these cases and what happens in the interim while the court is kind of wrestling with the back and forth of the legal proceedings?
Yeah, so the legal proceedings in the court are definitely lengthy and they are not quick. When one party institutes proceedings against the other, there are often requests of provisional measures, which open a whole new branch that has a hearing and an order by the court on provisional measures, if that is the case. Then the other party can present preliminary objections, and then there's a whole hearings and response, written statements, interventions regarding the preliminary objections, followed by an order by the court. Then, if it is decided that we can proceed to the merits, then there is the possibility for the counter memorial by the respondent. There are oral hearings as well, written statements, objections, etc. And then finally, the judgment on merits. So it is a lengthy process. What has been interesting is, as I mentioned, often when the application is filed instituting proceedings against the other state, and particularly in genocide cases, it is thought that there are some sense of urgent measures that are needed to preserve the rights of the parties until the merits are decided upon. So when there is a sense of risk or of urgency or of danger, then the parties often request the court to issue provisional measures. The court has issued provisional measures in the cases that are ongoing. In the first three cases, the Myanmar, Ukraine, and South Africa cases, those three have been object of provisional measures ordered by the court. So we have seen the court ordering, for example, in 2020, like very few months after the application instituting proceedings against Myanmar, we had a hearing and an order by the court ordering Myanmar to refrain from any genocidal act, right? Also, in the Ukraine versus Russia Federation, right after the institution of proceedings, 1 month later, not even a month later, we had an order ordering Russia to cease its military operations in the Ukraine. In the Israel case as well, we had 3 orders of provisional measures because of requests, reiterated requests to broaden, because of Israel's lack of compliance with the first 2. We even had a third one, and we had 3 orders on provisional measures where the court was ordering Israel to halt its military actions and to adopt many specific measures to alleviate the humanitarian situation on the ground. So we do see also the use of the International Court of Justice, maybe not so much for the final judgment, which will take ages, but for this order on provisional measures to get this kind of immediate response to try to halt ongoing conflicts as they are disinvolving.
Are there, enforcement of these measures is often the challenge, right? And you have countries who are, if they're engaged in genocide, they're probably going to be slower to recognize international legal limitations, obviously. Are there implications? So in a case like this where there are, orders that are put in place, even when they're ignored, does that have legal implications? Does that make the prosecution later easier, or is it not necessarily have ramifications along those lines?
I mean, in legal terms, provisional measures are binding on the state that receives the order on provisional measures. These are contentious cases where the ICJ has the authority, which has been previously granted to it by the parties who have accepted through one way or another its jurisdiction, right? So these are binding obligations. We do see that in these present cases, these provisional measures are not being complied with. And that does not help, of course, the case of the party in the merits phase. And that is, a strategy that the parties have decided to follow, regardless of the consequences inside the trial.
Should we shift to the question of individual responsibility and talk a little bit about the International Criminal Court? I feel like that's been, in many ways, more in the news than some of these ICJ cases. But can you talk a bit about the ways in which individual responsibility is handled by courts? And that is certainly more the ICC, but in the past it's been other bodies as well. Can you kind of walk us through that?
Absolutely. So the ICJ cases, and just to underline, they occur in parallel to cases that involve individual criminal responsibility. So it's not one or the other. These are two separate trials, two separate courts, two separate types of international responsibility. So in the International Criminal Court, we have seen one arrest warrant issued specifically for the crime of genocide. So the ICC has competence over the crime of genocide since it was created, since it started its functions in 2002. But it has only issued warrant of arrest for genocide in 2010 against former President of Sudan, Omar al-Bashir. And this was actually added to a 2009 warrant of arrest that had already been issued against al-Bashir for war crimes and crimes against humanity regarding the situation in Darfur. The situation in Darfur was referred to the ICC by the UN Security Council, and as most of you might know, Omar al-Bashir was overthrown, but is detained and facing supposed trial in Sudan, so he has not been handed over to the court. In the other ongoing situations that actually have cases before the ICJ that I mentioned, the Myanmar case, the Russia-Ukraine case, and the Israel case, we do have open investigations in the International Criminal Court. But it is interesting to note that in the arrest warrants that have been issued in these ongoing situations to this date, none of them have been yet arrest warrants for genocide. And there are very we can infer very clear reasons for this. So first of all, when you issue, as the ICC, when you issue an arrest warrant, that doesn't mean that you can't broaden it later. So you issue it at the beginning when you have a reasonable basis to believe some crimes have been committed. So if you have that reasonable basis evidence gathered for certain crimes, you will issue the arrest warrant for the crime that you have most evidence gathered, right? So in the case of Bangladesh, Myanmar, no warrants of arrest have yet been issued. There is a request to issue a warrant of arrest for the senior general and acting president Min Aung Hlaing, the commander-in-chief of the Myanmar Defense Services. But that warrant of arrest is for alleged crimes against humanity of deportation and persecution of the Rohingya committed in Myanmar and in part in Bangladesh. This is pending before the pretrial chamber. And what is interesting about the situation of Bangladesh, Myanmar, and the reason why Bangladesh appears there is that Myanmar is not a state party to the Rome Statute. So the only way that the prosecutor could request the opening of an investigation was to find a jurisdictional basis. And because so many Rohingya, there are more than 1 million Rohingya today living in Cox's Bazar camp in Bangladesh, because of that, there have been arguments put forward that these crimes, particularly the crimes of deportation and transfer and persecution of the Rohingya, are continuing on Bangladesh territory. And that is giving the possibility of a territorial jurisdiction for the International Criminal Court to know of the case. So this is interesting. In the Ukraine situation, again, Russia is not a party to the Rome Statute, just as Myanmar. And in the Ukraine situation, however, we do have the Ukraine having first accepted the jurisdiction of the court on an ad hoc basis and now a full party to the Rome Statute. So the Ukraine referred its own case to the ICC. The ICC actually issued, in these cases, warrants of arrest, first in March 2023 against President Vladimir Putin and against his Commissioner for the Rights of Children. It is interesting that on this occasion, the arrest warrants were for the war crimes of unlawful deportation or transfer of population as a war crime, not as anything else. In March 2024, further warrants of arrest were issued against the air and naval authorities for war crimes of directing attacks against civilian objects, causing excessive or incidental harm to civilians or damage to civilian objects, and for the crime against humanity of inhumane acts. And finally, in June 2024, for the former Minister of Defense and his former First Deputy, also arrest warrants were issued for war crimes of attacks against civilian objects, excessive incidental harm to civilians, and crime against humanity of other inhumane acts. So as we can see, genocide is not in these alleged crimes under these current arrest warrants. In the case of Palestine as well, on 21 November 2024, arrest warrants were issued against the highest commander of the military wing of Hamas for the crimes against humanity of murder, extermination, torture, rape, or sexual violence, war crimes of murder, cruel treatment, and torture, and also against Mr. President Benjamin Netanyahu, Prime Minister of Israel, and Mr. Yoav Gallant, the Minister of Defense of Israel, for war crimes of starvation as a method of warfare, and for intentionally directing an attack against a civilian population, and for crimes against humanity of murder, persecution, and other inhumane acts. So again, no arrest warrant issued for genocide, probably because of the difficulty to prove the genocidal intent. As you know, genocide, and this has been reiterated by the ICJ and by the ICTY and the ICTR, the crime of genocide is one that requires the specific intent of destroying a national, ethnic, racial, or religious group as such. And the proof of that is a very difficult one. So it makes sense that in the first instances of these ongoing situations, the ICC would issue arrest warrants only for those crimes for which it has enough evidence. Again, the purpose of the arrest warrant is to actually get the person detained, right? And in any case, we all know that these people that are subject to these arrest warrants are not being detained because the ICC does not have its own police force that can go into and violate state sovereignty and detain a person. That would be against all the principles of international law. So it depends on the cooperation of states parties. As long as there is a warrant of arrest already issued, the purpose for the moment of having, the legal basis for that person's detainment is out there. It's already there. If in the future the ICJ decides on genocide regarding any of these cases, then we might see possibly a broadening of these arrest warrants for the crime of genocide. But I do think that the court will be very conservative before that.
So just to build on that, and I will, Paul, well, after this, we can take questions if there are questions from our participants. But this is the challenge, right? I mean, I think people get frustrated because they want to know why have genocide, but genocide is a very specific legal definition that has multiple parts and it deals with jurisdiction and all these other things. But again, in this particular instance, it's that question of intent, right? So the transporting of minors, the use of starvation, these are all crimes that fall under these are things listed in the Genocide Convention as the sorts of crimes that can meet the criteria of genocide. But the key is proving that the intention was genocidal. So what does that look like? How does a court prove intention? Can you talk about that? And because that's something that comes up in both the ICC and the ICJ.
Absolutely. And it comes up in both courts, but with a different burden of proof. In the case of the issue of the deportation or transfer of children, for example. So, while yes, the forcible transfer of children from one group to another with the intention of destroying a national, ethnic, racial, or religious group as such is genocide, it also makes sense that in the Russia-Ukraine case in 2023, when some of these children were being transferred to Russia, the court said, okay, I already have a legal definition under war crimes. A forcible transfer of population where all that I have to prove is that there is an ongoing armed conflict and that people were forcibly transferred from one state to the other. So that is a much easier crime to prove. And that is much easier to justify why the warrants of arrest were issued for that moment for the war crimes of unlawful deportation of population and not for the genocidal crime of transfer of children from one group to another, because then you don't need to prove this intent to destroy the group. If, of course, if there is enough evidence and the ICC decides to broaden it, it will do so. It's interesting that in the Russia-Ukraine case, the ICJ is not being asked to pronounce itself on whether Russia is committing a genocide, but it's actually an inverse case where, because the fact that Russia's invasion, and I'm going back to the slide of the ICJ for a second, because Russia had alleged that it was invading Ukraine in exercise of its obligation to prevent a genocide by the Ukraine in the Donetsk and Luhansk areas, then the Ukraine is asking the court to say, please confirm that the obligation to prevent genocide does not in any way allow a state to invade another country. So that is what the Ukraine is asking the court to state. And then, of course, it is asking it to state that the Ukraine did not commit genocide. So it's not a case alleging that Russia is committing genocide. So it's a little bit different. In the other cases, and I'm going back to the ICC again. So in the other two cases, and going to the Palestine case. So the Palestine case, of course, is highly, highly politicized and controversial. And of course, the courts have to be very, very cautious and very careful in the way that they handle it, because one way or the other, in either the ICJ or the ICC, one way or the other, it will receive criticisms from one side or the other. And so in the case of Palestine, we can see that there were arrest warrants issued for war crimes and for crimes against humanity, and that they were issued not only against the Israeli side, but also against Hamas leaders. And this is important to note because the ICC, the International Criminal Court, being it that it can prosecute individuals, this court can actually go against Hamas leaders, which is not the case in the International Court of Justice. So in the International Court of Justice, you cannot see a non-state party as an accused party. You can only see states. And that is why the case regarding Gaza only concerns Israel, because you cannot take Hamas to the International Court of Justice. So these are considerations that have to do with pros and cons of one and the other court, and where both are actually complementary. And maybe one final point also, it's interesting to note that sometimes, and I say this mostly because of the Ukraine-Russia case, but in many cases, there are no other conventions that allow to take a state to the ICJ. So even if what we are facing is most probably, in most of these cases, war crimes, the fact is that the Geneva Conventions of 1949, which are the conventions that set forth international humanitarian law, the rules of war, those do not have a clause that says that any dispute regarding the application of those rules will be taken to the ICJ. So when you have a state like the ones that we are seeing here, when you have a state that doesn't have a permanent declaration of acceptance of the competence of the ICJ, you have to find the way and you have to find a convention of which it is a party. So that's why we are seeing so many allegations under the Genocide Convention of cases that we don't really know if the ICJ will conclude that they are genocides. These are attempts to bring states responsible to the international community through the only jurisdictional via possible, which is the Genocide Convention.
It's fascinating. So if other people have questions, please add them to the Q&A. I do have one question here that I'll give to you and see if you can speak on it. One of the questions is about what measures the courts take to try to reduce the re-traumatization of survivors when cases are being heard. So is that how do courts handle the sensitive issue of these cases? I'm not sure if you know much about that. I know that I know a little bit about it, but I'm sure know more.
I'm sure you know more, but all I can say, and please compliment me here, Phil. But for example, in the reparations in both courts are they follow the same general obligation. So under international law, reparation can take four different forms. So it has to be either restitution, which is to restore the situation to the way it was before the violations. Of course, in cases of genocide, this is not possible because you have human lives involved most of the times, or you have very, very serious trauma and injuries as well. So restitution, you also have compensation, so ordering payment in, money to victims. You have satisfaction and you have guarantees of non-repetition. So satisfaction can take many different forms. Satisfaction can include, for example, programs, community programs to, strengthen the resilience of society, to provide psychosocial support precisely for trauma affected communities, to provide the building of schools, of memorial sites, of education centers, etc. So satisfaction takes a broad type of forms, and then guarantees of non-repetition, which is literally the promise of not doing it again. And it's also very important to note that. For example, the International Criminal Court does have a trust fund for victims. In the case and I'm going to the ICC slide, just so sometimes the people who are prosecuted in the ICC, their assets are used, they're frozen, and they're used to compensate the victims. But victims for atrocity crimes are so many that the assets of the perpetrators are, very, very, very insignificant compared to what is needed to repair and to try to reconstruct the society. So there's a trust fund for victims where states and other international actors donate funds, and then the ICC uses those funds in part to repair. The orders on reparations have a very important focus on the collective because of the number of victims. So a very important focus on the collective aspect of atrocity crimes. So, for example, as I mentioned, maybe, some measures that will benefit the whole village, for example. Of course, there are compensations against each family, but sometimes those compensations have been really low compared to the collective aspect of the reparation. So, and psychosocial trauma is involved in these reparation measures, mostly in the ICC cases, less so in the ICJ cases, precisely because the ICJ cases have been, on other topics, maritime boundaries, etc. But of course, for genocide, there are some compensation measures that have been ordered.
Great. I'll add one little, this is just a little detailed tidbit that I find interesting. When you go to the International Criminal Court, they have incorporated through architecture some of this protection. So these cases are obviously of great public interest, but they have set it up so you have viewing galleries and whatnot. But the witness stand is out of view. So the people, people who come in and testify, victims, are intentionally kept anonymous. They're visible to the defendants, but not to the public as a whole, which I think is a really interesting aspect. We're just about out of time, but let me ask one more. I think we have a couple of minutes. You and I had talked to this when we were talking about this in the previously. There's some interplay between the ICC and the ICJ in terms of, things that develop at the ICJ might add strength to ICC cases, or what happens at the ICC might strengthen ICJ cases. Can you talk a little bit about that and how that has played out in the past or how it might be playing out now?
Absolutely. And just to add another thing that came to my mind also is that there is I just forgot. I'm so sorry. I had it on the tip of my tongue. I'll come back to it in a second. So yes, there is this interplay among courts in the sense that in the cases, the past cases, the 2015 and 2007 judgments on the former Yugoslavia, those are judgments that took into account what the International Criminal Tribunal for the former Yugoslavia had mentioned on or had prosecuted regarding genocide. So it had already cases of an international criminal court that fed into its own reasoning, and it used it and it supported its own arguments on that. What's interesting of the current cases is, of course, that the court doesn't have yet any cases regarding international criminal responsibility for these situations because, as I mentioned, these are ongoing also in the ICC. So there has been an interesting recourse by the International Court of Justice to other types of documents that are not necessarily legally binding. For example, in the Myanmar case, it made use of the report by the UN fact-finding mission of the Human Rights Council, a fact-finding mission that said that there was a reasonable basis to believe that genocide was being committed by the state and by individuals. So, a non-jurisdictional body is being cited by a jurisdictional body as a basis to give it jurisdiction prima facie. This jurisdiction prima facie that the court needs in order to be able to indicate provisional measures, for example. So this is important. Also, the way in which the genocide is proven is different in each case, in each court. So the burden of proof is much more lenient, if I may say that word, in the ICJ because you're dealing with state responsibility. So what do you have to find in the case of the International Court of Justice? You have to see if there is a state policy, which normally state policies are not explicit about their intent to commit genocide. And if this is not the case, then you have to see if it can be inferred from a pattern of conduct, of which the only conclusion possible, the only inference possible that can reasonably be obtained is that it was a genocidal intent. So the burden is the only inference possible, okay? So that is, quite broad. In the case of the International Criminal Court, of these cases where we see a lot more, conservatism by the court in going forward with genocide allegations immediately, it's because in order for the court to, first of all, to open an investigation on a state, that is a broader burden because all you need to know is that you have reasonable a reasonable basis to believe that these crimes have been committed. That's what the prosecutor needs to ask the judges to open an investigation. Reasonable basis to believe, that's fine. But then when the judges have to declare somebody guilty of these crimes, the burden is a burden of beyond reasonable doubt. We are speaking about individual lives and their liberties and people who will be put in prison. And so this is a very strict burden of proof, which is much more difficult to reach in criminal cases in the ICC.
It's really interesting. I think we are just about out of time. Yeah, I could keep talking to you about this for a really long time, but I think our time is up. So let me just again thank you so much for taking time to join us. Your expertise is so valuable, and it's so interesting listening to you. So thank you again, Mariana, for your time. And
Thank you, Phil. And I just remembered I was just going to speak that there are witness protection programs between the ICC and states. So they relocate victims and witnesses to states that are willing to take them on secretly, and undercover. Mhm.
all
Thank you
right,
so much.
thank you.
Bye bye.
Bye.
Phil and Mariana, thank you for such a meaningful conversation today and for helping our audience think through some of these complex realities regarding the prosecution of genocide today. So thank you again. And thank you to our guests who joined us today for today's lunchtime critical response event. And as we wrap up, the Cohen Institute would just like to welcome everyone to attend our other critical response events throughout the year, including our upcoming critical response event on the situation in Haiti, which is taking place on Friday. You can find more information about these events and other programs by visiting the Cohen Institute's website. So thank you for joining us.